Court, September 20th, 2017 order. I'm going to skip on the agenda. I'm going to get the guests. Bill and Holland, I know their presentation's not going to be long, so we'll go ahead and start with them. Good morning, sir.
Good morning, Judge, Deputy Judge, court members. Thank you. On behalf of Peel and Holland and Kentucky Association of Counties, glad to report some findings we've had from the request for proposals for this year's health care and other benefits. I won't bore you with the details in terms of reading it. I've given you a two-page front and back report. Overall, the Kentucky Employees Health Plan through the state of Kentucky Commonwealth is going to be up 3% this year. That's an increase that is fairly small compared to what we're seeing in the marketplace. Back in 14, 15, 16, and then this most recent year, other than the standard consumer-driven plan, the rest of the plans haven't changed. So this is the first real increase we've seen in several years. Total dollar value of that overall to the county is about $45,000 on the fiscal. So we did take a look at other plans, options, and carriers. I put those results in the center of that first page. Humana came in 20% over current, so that'd be obviously 17% more when you look at the increase from the state. United Healthcare declined, saying they were not going to be competitive. Anthem hasn't responded as of this time, which typically means they don't believe they can match the rates. And so we also then took a step back and looked at if you had tried to run your own plan like outside the state, given your claims and your premium paid to the state, would you have come out better or worse? So this year you would have come out better, but if you go and buy reinsurance and you buy administrative services, you would go back in the deficit. So we're still at a place where I think the state's the right option. Just as a reminder, for folks who waive the plan, they get $175 a month into their health reimbursement arrangement. And then the county, since 2014, has provided some HRA dollars to the members as well to supplement their plans. On page 2, really not a lot of changes there as well. Most of these other plans outside of the life insurance, which is county provided, there's no rate increase on the life insurance, so that's a renewal if it be the court's pleasure. Delta Dental is employee paid, and it's up 3%, which is very common. 3 to 5 is what we're seeing in the market for dental. Vision through Avisus is a rate hold. It's in year 2 of 2, so we'll look at it again next year. And then we have some other voluntary plans, and to my knowledge, those are not changing. So I think it's really good news. I've delivered several renewals this fall that have been excess of 20%, probably with the majority being between 9 and 12. So I think a 3 is really good where we are. I also took a look and said, if you wanted to try to do this on your own, how could we get back to the state's cost? And the only way to do that I can find is to either cut benefits or raise the employee's share significantly, or both. So I just don't think that's necessarily a good play for the county or its employees. So again, my recommendation is we stay the course with the Commonwealth of Kentucky Employees Health Plan for another year.
Y'all have any questions?
Greg, this takes effect in 2018?
January 1.
Okay, okay.
So we'll be going through the process with the Treasurer's Office and personnel, making sure we get everyone re-enrolled in the new year and get them all up to date and get them in the system.
We've got open enrollment tentatively scheduled for October 11th and 12th, so that if you wanted to not make an approval at this time, that you all could have time to review it and make an approval at the next meeting, if that's what you so chose to do.
Y'all have any other questions? Appreciate it. Thank you, sir.
Thank you very much. Have a great week.
If we want to, we can make a motion to sign it today if we want to do that. Since we got open enrollment coming up.
I think he's weighed all the options, and there doesn't seem to be many options.
No, this is a very good.
No brainer.
I'd move that we go ahead and sign in for this KCO health plan.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. We'll go back up on top on the guest list. Levin Law Firm, Jeff Gaddy's going to give us a presentation on the opioid litigation. Good morning, sir.
Good morning, Judge. Thanks for having me here. My name is Jeff Gaddy. I'm with the law firm of Levin Papantonio out of Pensacola, Florida. My law firm, along with about 4 other national law firms, have been here in Kentucky for about 2 months now. What we're seeking to do is represent local governmental entities in litigation against the pharmaceutical distributors for what we believe them being one of the main culprits in the opioid epidemic that is so adversely affecting so many of the counties here in Kentucky. We've been working in this field for quite some time. We represent and have filed lawsuits on behalf of 7 counties in southern West Virginia. We represent and have filed lawsuits on behalf of approximately 15 counties in southern Ohio. And we represent, as of yesterday, approximately, we have signed contracts with, I believe, 25 counties here in Kentucky, and about another 10 that are waiting for their next fiscal court meeting to join up. We filed lawsuits on behalf of 20 of those Kentucky counties. Our client base in Kentucky is diverse. We represent and have filed lawsuits on behalf of Jefferson County and Louisville, other large counties such as Boone, Franklin, Madison. We've also represent and have filed lawsuits on behalf of some of the smaller and more rural counties, including Bell, Whitley, Knox, and others in eastern Ohio that have been particularly hard hit by the opioid and public health crisis. Our, our goal in this litigation is to recover 2 separate buckets of damages for the counties. The first, which frankly we believe would be the smaller of the 2, but would be retrospective, looking back. What were the additional costs that the counties had to pay out to deal with this crisis? Whether it's law enforcement expenses, jailing expenses, whether it's EMS cost, the cost of Narcan, all the costs and expenses that come along with dealing with this crisis. The second bucket of damages that we're looking to recover for counties is prospective, so forward-looking. We allege that these companies have been complicit in creating a public nuisance and a public health crisis that has adversely affected virtually every county within Kentucky. And what we're going to ask these companies to do is pay the amount that it costs to put all of the counties, including Marshall County, back in a position that they were in before the flood of pills began to happen into the area. We'll ask them to fund the abatement of this nuisance. What would it cost to put in place an educational program so that we can make sure that we get into the school systems and make sure that the children know that the pills in their parents' cupboard are just as dangerous as a needle? What do we have to do to make sure that the children know that if a heroin needle goes into their arm one time, it's probably not going to be the last? On the other hand, the other thing that we need to make sure we fund is law enforcement. We need to make sure that they're adequately protected so that when they do a traffic stop on the side of the road, they're not coming into contact with fentanyl and overdosing like we've had law enforcement officers do in West Virginia and Ohio. We need to make sure that law enforcement and the jailing have the adequate funding that they need to make sure the community stays safe while we try to deal with this problem. And third and foremost, by way of abatement fund, we would be asking these companies to fund the addiction recovery services that are so desperately needed. Every law enforcement officer that I've talked to has come to the same conclusion. This is not a problem that you can arrest your way out of. It's a vicious cycle of addiction, and only by treating the root cause of that addiction can we ever hope to make any gains. So that is the general proposal of the lawsuit and what we're looking to recover. As I mentioned, the primary targets of the lawsuit would be the pharmaceutical distributors. They, without getting too much in the weeds, these distributors have certain federal and state laws and regulations that require them to essentially be the beat cops when it comes to pills getting to the streets. They have control over the spigot. They are required under federal guidelines, including the Controlled Substances Act, to be on the lookout for, identify, and report to the DEA any suspicious orders of controlled substances that they receive from any pharmacy, whether it's brick and mortar or online. Their obligations require them that if they see something that is suspicious, and suspicion can be dictated by the size of an order, can be dictated by the frequency of an order from a certain pharmacy, or it could be indicated by any deviation from the normal pattern. If they see anything like that, they're supposed to immediately pull the box of pills off the back of the truck, put it in the corner, and either do their own investigation and determine that there's nothing going on there, or call the DEA. This issue first came to light in 2012 when the Attorney General of West Virginia filed a lawsuit against the pharmaceutical distributors. During the course of that lawsuit, the Attorney General's office came into possession of what's called the ARCOS database for the state of West Virginia. ARCOS is a confidential DEA database that contains the information for every order of opioids ever filled by any distributor. As that litigation was going on, somebody whispered into the ear of a journalist with the Charleston Gazette. That journalist intervened into the lawsuit, got his hands on the ARCOS database, and wrote a series of articles that won him the Pulitzer Prize. What he reported and made public for the first time was that in the state of West Virginia, which has a population of 1.8 million people, that over a 5-year period, these distributors had flooded the market with 780 million pills, which is absolutely off the charts by any scope of measurement. The other thing that they found was it's not that these companies did a bad job of identifying and reporting suspicious orders of pills. They found that they didn't do it, period. They completely and totally disregarded their duties under the federal law and under the state law of West Virginia, and that Attorney General successfully pursued that lawsuit against several pharmaceutical distributors. That is the very gist of the lawsuit that I'm proposing. We would very much like to have Marshall County pass a resolution and agree to join in the litigation, and I'm happy to take any questions that y'all might have, with the caveat that if we get into litigation strategy, I'd prefer to answer those in an executive session.
In which I'm sure you're aware, the reason he's talking about West Virginia, Ohio, and Kentucky is that we are the epicenter of the opiate abuse in this country. And that's the reason that it's so important. And these, like he said, this litigation will be directed at the wholesale distributors, the ones that aren't following the federal law in governing their distribution. And something else that I noticed in our presentation at CAECO, and then that there are 80-some distributors in this country.
There's about 800 distributors.
800?
There's 800 distributors, and
3 of them control over,
85%.
what?
85% of the
Yeah,
market.
3 of those distributors out of 800 control nearly all of the market.
So those 3 distributors are McKesson Corporation, which is out of San Francisco, Amerisource Bergen, which is out of Pennsylvania, and Cardinal Health out of Dublin, Ohio. They're not Fortune 500 companies, they're Fortune 15 companies. They have combined annual revenues of over $400 billion. So they are giants in every sense of the word.
Sure, they've got good legal representation on their side also,
I'm sure they do.
if they're in that category.
I know Jeff gave a short presentation. I've listened to the other lengthy presentations, both at CAECO and the Kentucky Judge Executives Association, and to hear some of the attorneys that are involved, some of their stories and how they were affected, and with their own personal families or even within their own communities. It really is. I wish we could bring that to our community so they can hear that story. We may not be in the center of the epicenter, but there are some crisis areas, and I know for law enforcement, they are, and EMS, they've got some challenges on their hands. It literally sucks up all the resources in these communities. But I wanted to have him here today to give the presentation to the Fiscal Court so that you can be aware of it. You should have gotten the information prior to the weekend to go over it. They had put a very detailed description of the claims against the opioid distributors, so it's some really good information. I know as soon as you get done here, you're going to, I believe it's McCracken County.
Yes, sir. I was in Henderson County yesterday and go to McCracken after this.
So there's some other counties that are still looking to hear from the law firm with their presentation. Do any of y'all have any questions?
I haven't reviewed this, and I intend to, 72 pages or so, but basically, what is our initial investment, or is it just a resolution? What are we talking about, skin in the game?
Sure. Cost to you is zero. We will front all costs of the litigation. It's a contingency fee contract. 30% is the percentage. If we don't recover, you don't pay anything. If we do recover, then the recovery, or our fees would be 30% of the gross recovery. So you're right, it's bulky. Probably the first 5 or 6 pages is a summary of in a
Tells
little
the
more
story.
detail than what I just told you. After that, you'll find some documents. All of the, we're not making up this conduct. These companies have paid over $200 million in civil fines to the DEA for exactly this conduct. So we included in your packet some of the agreements that these companies came to with the DEA, where they admitted to this conduct and where they agreed to pay. McKesson in December paid a $150 million fine. Cardinal Health has paid multi-million-dollar fines for this exact conduct.
I was present at the presentation at CAECO along with the judge back some time ago originally, and then at that presentation, Michael Connell, a county attorney from Jefferson County, and Mike Foster from Christian County were both present, and I met with them again at the prosecutors conference in August. We compared notes and what we had found and looked at the contracts and documentation and this group of firms that are doing this, and they both Christian and Jefferson have signed on since then. So there were, without going into great detail, but they were convinced by that point in time, and their courts have signed up.
The Pulitzer Prize may have been awarded in 2012, but it's been going on a long time before that.
You're right. It was actually
Long time before that.
You're right. It was actually just awarded last year. That's when the information finally became public.
And correct me if I'm wrong, with the approach you're taking through federal court and filing it based on a public nuisance claim, that's a reoccurring nuisance and has no statute of limitations.
Correct. The statute of limitations doesn't run until the nuisance is abated, which obviously it has not been. So what we are asking the court to do is we have a proposed resolution that we'd ask the court to address if it found appropriate. The resolution essentially declares that the court recognizes that there is a problem as it relates to opioids, and it would authorize Judge Neal to enter into a contract with our consortium of firms and pursue a litigation against them.
And their process in determining what the damages are would be an analysis of this community and determine what we need to combat it, where we are in regard to the problem, treatment, education, those things, all dollar value are placed on those. And it wouldn't be that the court suddenly has a pile of money at the end. If you're successful, you would have the money to spend on these facilities and projects to combat the opiate problem.
And nothing of the cost that we bared ongoing from last 10 years. We'll have
Yeah.
a pile of money, but I understand where we'll have monies for programs and stuff, but what about the monies that we've spent as a county? Certainly, I would think that would be figured in over the last 10, 15 years or whatever.
Yes, sir, that certainly would be one of the goals of litigation, to document the added expenses and added costs that the county's incurred. You're right, going back to about year 2000 is
Sure.
kind of what we've pinpointed.
Okay.
I'll add this, if you don't think that's a problem here in Marshall County, you're right, you're badly mistaken. It's here, it's not on the levels up in Jefferson and northern Kentucky, it's here though. We deal with it every day, every single day.
Yeah, like the other parts of Kentucky, our illegal drugs, non-prescription type illegal drugs are diminishing, but the opiates are, I mean, if you go from Lexington towards northern Kentucky, I mean, they're not dealing with meth cases anymore. They're dealing with this right here. I forget a minute, they told us how many overdoses a day in Jefferson County.
Well, not just Jefferson, but you get into like West Virginia, it was staggering.
Yeah.
It was unreal. I couldn't believe it.
But when you got ambulances carrying cases of Narcan on their trucks, not one or two doses, cases of it. And that's what they're experiencing up that way, and it's slowly making its way down here.
Right. I know I've listened to the presentation twice. And I support it because I think we need to get out in front of it. So that's my position. I know the team that's prepared, you guys are, I think there's it should be in your packet, the lawsuit with DuPont. I mean, what you're bringing to the table is far greater than what we can do in a small community here. So I get it. I know that other communities are jumping on board and supporting this. I think even the Attorney General's office was looking at it, but I think at the local level, we know what our problems are with our leaders here, and we don't want to wait till that epicenter expands and we're part of it, so.
I think you're exactly right. I think the Attorney General does have losses from Medicaid and otherwise, but you know, we're firm believers that local counties have local problems and they need local solutions. And we think a county-by-county approach has the ability to provide those local solutions that can be tailored to exactly what Marshall County would need to address this issue.
I will echo and agree with what the judge said. I encourage the court to support this.
The resolution is in your packet. If you've read it, we can take action today and join in the litigation.
And we've gone through the fee agreement, and with only a couple issues, and we've been satisfied that regard to our questions.
You said there's been a couple of issues?
Yeah, there was one, the one we discussed this morning about non-monetary, how did that read?
It was paragraph 2.
Yeah,
Correct. It had to do with the fee would be based on the value of the recovery, monetary or non-monetary. And as we discussed there, the issue there was that the county has the ultimate authority over any resolution to this case. The county retains 100% authority in how to resolve the case if it's by some means other than trial, and therefore the county can ensure that any settlement or any recovery includes the ability to pay any attorney's fees that would be.
yeah, when they start, if we get to the point where they're putting money on the table, and for different, we just need to make sure we're careful in how we're applying that so that we cover our expense with those monies. That's all it is. It's not suddenly that we're going to cruise through this, not have any say-so, and there's some big judgment, and we wind up having to pay the attorney's fees over and above that. That's not there's a way to avoid that in this contract.
Whose responsibility is that on behalf of the county to be the watchdog, that doesn't happen?
Do what now?
Whose responsibility is that within this county to be the watchdog to make sure that scenario doesn't happen?
Well, anything they do, I mean, they don't have authority to settle anything without the county, without your all's vote.
Correct.
And I mean,
So
obviously, I'll be.
Fiscal court then.
Yeah, and obviously, I intend to be involved in, as far as knowing where we are, regularly, so that I can report to you all as to where we are and what's going on. And because I think what you will find is, as soon, when you do this, there's going to be a lawsuit filed in the next 2 or 3 weeks.
Yes.
It appears that if you recover, there's no fees unless there's a recovery of
Correct.
funds, and that's at 30% then, that's what it says.
And y'all are going to advance all necessary litigation expenses.
Correct.
I think the ultimate goal is, with a win in this litigation, those companies that are supposed to police themselves will start policing themselves. And I think the analogy that was used, law enforcement arrests an individual, they throw him in the jail, and then when they release him, they ask him to stay dry. When he walks out the door, there's a monsoon. And that's the volume that you gave numbers for West Virginia, the 780 million pills that were coming into a 1.8 million community. The expectation can't be met. It's an epidemic to where the user needs help. And locally, we know better than the state, or even at the federal level. We know what our problems are locally. So the bigger picture is, if there's a win in this litigation, we would start to see some improvements on that volume, those pills coming into our community.
That would be our hope.
How's this impacting our doctors and their ability to prescribe in any way, or?
This lawsuit does not target local doctors. It does not target local pharmacies. We're not going after the street-level dealers. We're going after the cartels.
And most of this is bypassing our doctors. I mean, this is coming in getting out there in other ways besides through what I thought.
Yeah, this is not just your everyday,
Exactly.
pill seller. This is in large volumes.
Do we want to take action on this resolution?
I'm prepared to today. I think it's certainly good for Marshall County and the surrounding counties, and certainly I think that the price is right, so I move that we adopt. Give the judge authority to sign the document.
All those in favor, say aye. Any opposed? Motion carries. Mr. Gaddy, I'll just, I don't know how long you're going to stay around, or if you've got to get to McCracken County, you've got my contact information, and
I do, and we'll follow up by email. Thank you.
thank you, sir.
Why don't, just for the record, why don't I read the resolution into the record?
Sure.
This is a resolution of the County of Marshall, Kentucky, authorizing, approving the directing of employment of certain law firms to represent the county in potential litigation against contributors of opiate addiction crisis. Whereas the county is experiencing serious opiate use as a result of the ready availability of the drug and its abuse, and whereas the county desires to retain the law firms identified herein to advise and represent the county regarding litigation and award of damages from the contributors of opiates within the county. Now therefore be it resolved by the Fiscal Court of the County of Marshall, Kentucky, as follows. Section 1, the Fiscal Court, as the governing body of the county, hereby authorizes, approves the employment of the law firms identified in the legal services agreement attached here to incorporated as Exhibit A, herein referred to as the law firms to represent the county in potential litigation against contributors of the opiate addiction crisis. Fiscal Court hereby authorizes and approves or confirms authorization and approval of legal services agreement substantially in the form attached hereto, incorporated herein by reference thereto as Exhibit A, and directs the judge executive to execute and enter the legal services agreement with the law firm, setting forth the scope of the work to be performed by the law firms, including litigation against contributors to the opiate addiction crisis within the county, and the terms and conditions of the employment of the law firms. The legal services agreement may be amended after approval of this resolution without further action of the fiscal court with the approval of the judge executive, whose signature on the legal service agreement shall be evidence of such approval. If any section, paragraph, or provision of this resolution shall be held to be invalid or enforceable for any reason, the invalidity or unenforceability of such section, paragraph, or provision shall not affect any of the remaining provisions of this resolution. This resolution shall be in full force and effect from and after its adoption as provided by law. The resolution was introduced, seconded, and adopted at a duly convened meeting of the Fiscal Court of the County of Marshall, Kentucky, held on September 20th, 2017.
Okay. We're going to move on to guest, Rivercrest, Chad McCain. Good morning.
Thank you all for having me. Here to provide an update today. Number one, we've been doing some work with the Fiscal Court and with the sanitation districts in Aurora and Draftonville, sanitation districts number 1 and 2. I want to give you guys an update on our status, the projects we've been working on. First item of business, I think Brad's pulled it up here on the projector screen. We had received bids for the lift station improvements projects in Aurora back on August the 17th. And I believe you guys may have a packet of material there that you've seen. Excuse me. As a result of those bids that were received, you can see the 3 bid amounts that were received from Youngblood Excavating Contracting, Merco Utility Services, and WK Industrial. Since that time, on August the 17th, since we received bids, Rivercrest has been performing a review of the bids, and also we entered into negotiations with the apparent low bidder, Youngblood Excavating Contracting, to discuss their bid and basically just look at ways where we may be able to work with the sanitation district, meeting the intent of the project and all the needs of the lift station and the sanitary system down there, and possibly trim some of the costs there. Knowingly that the bids came in a little bit over the budget, wanted to do some diligence on the front end to work with them, work with the contractor, and basically work on both ends. Work with them, go through each line item. Given the delta on the bids, we also wanted to go in those discussions, make sure there weren't any misunderstandings within the bid items, make sure that basically everything was clear in our procurement package, and that the contractor was viewing the project intents the same way we were from the design end and the operations end from the county and the district's operator. As a result of those discussions, had a meeting with the contractor on Monday to basically allow them to present their final numbers based on those discussions and negotiations. And based on that, a revised proposal was provided by Youngblood Excavating Contracting. I believe that's in your packet as well. And at this time, they were successful in trimming, say, approximately $42,000 from their bid amount. The primary reduction in that was the size of the generators. Initially, whenever we presented this proposal and the proposed project to the fiscal court back a little over a year ago, we didn't include the aspect of a standby generator at these lift stations. And when we got into our evaluations, we found it was necessary to have that. I know Lindell Operator has had a couple instances when he's gone to Aurora, bouncing back and forth between Draftonville and Aurora, and been identified that he had a power outage down there. He didn't have any backup power at a lift station, and therefore it caused an overflow in a sanitary system, which had to be addressed. If a generator would have been on site, that would have been taken care of automatically through a diesel-powered generator system and kept the system functioning properly and kept everything flowing. So those were added in as part of these lift station design packages, and we were actually, again, able to trim those sizes down. Basically, we took the size of the generators and we went from running 2 pumps simultaneously down to 1, and each pump is designed to handle the design flow coming to each station. So we're still meeting the intent of the project, but we were able to reduce the size of the generators from 60 kW to 30 kW and still meet the intent of the project. So that's where the bulk of the savings came from, and the contractor did sharpen their pencil a little bit and provided some benefit to the county and the sanitation district. So if you're looking through your package there, basically we're here today basically explaining this recommendation and stating that Rivercrest recommends that the Fiscal Court accept the bids as provided on August the 17th and award the contract to Youngblood Excavating and Contracting for the amended contract amount as presented in their proposal and as by the contract change order number 1 that was provided in that packet, which modifies the cost from the 686 down to the 644.
Are they from Mayfield?
Yes, sir. We've actually worked with them on a water line project in Calvert City a little over a year and a half ago. We hadn't had any experience with them from the sewer aspect, but we did call the references, talked to the folks in Benton. They actually did a lift station project for them over the last year or so in coordination with the construction of the new middle school. And then they also had done some sewer work, lift station work in Mayfield. We talked to the folks over there, made sure everybody was happy with their workmanship, quality of the work, and end products. So we feel comfortable with the contractor and the staff that they're bringing to the project.
What was budgeted? You said that's gone down to $42,000. They sharpened their pencil, and what was the actual budgeted amount?
The original estimates that were prepared, which did not include the generators, was close to $500,000. And then as part of the design package, we actually added in the generators after discussions with the operators.
Was that the additional $150,000 cost then?
Actually,
Generators?
Based on the initial bids, if you break out the electrical costs and look at it, there was probably about, I'm not going to give you the exact number.
Well, I don't want
but
the exact number. I just.
one of the, it was over $200,000, $250,000 probably, as far as the electrical package for all 5 of the lift stations. So yes, I would say the generators and the manual transfer switches and the automatic transfer switches were a bulk of that cost. Yes, sir.
And the bids were opened the 17th, is that correct?
Yes, sir.
We didn't do that here, did we?
We did it over at the old fiscal courtroom is where they were open.
Okay.
If y'all have any questions about the fine details, you got a copy of the bid tabulation in there also. I can discuss those items with you if you're curious.
Do y'all have any questions? Chad, can you explain the difference from the description of work that was originally submitted back, was it 2013 or 2016 when we had the, because this is the same project. We've been on this project for a while, but the description as far as the work that was going to be done to those lift stations. The reason why I want you to explain it is where we're at today. I feel like we're doing it right. We're not putting a Band-Aid on a problem. We're actually fixing it the way it needs to be fixed. But can you explain the distance? Because there is a cost difference.
Sure.
And I think I want the court to understand why there's a cost difference.
Okay. Can do. Back whenever Rivercrest entered the project, back at the beginning of 2016, we did evaluate the bids and the project specifications for the original project that was put together. In review of that, the general, I'll summarize what was included in those original packages. Each lift station, there was going to be a new small lift station placed at the Lakeland Resort. Outside of that lift station, they were basically going to do a rehabilitation effort on each of the other lift stations, the other 4 lift stations, and that included basically not including any structural improvements other than some painting, some coating of the interiors of those wet well and valve vault structures. And they were going to replace some of the valves, and those valves were actually purchased as part of the agreement and with the grant monies that were obtained from DRA, and basically doing some small electrical improvements to each lift station as well, which would include the replacement of the control panels and the wiring of the pumps from the pumps to the new control panels. And that was the general scope of work included at each lift station. Whenever we got to looking at it in finer detail, we noticed that several of the lift stations were undersized based on today's standards and the Kentucky Division of Water standards, which we're bound to. We found that from a capacity standpoint, the lift stations simply were not sized appropriately, or they didn't currently exist at a capacity to handle the flow that would go to them. So we looked at it more from a permitting standpoint, we looked at it from a capacity standpoint, and also from a long-term standpoint. The methods that were proposed, in our opinion, with the original bids were basically, as the judge said, more of a Band-Aid effect. Whenever you coat the interior of a lift station with a paint product, even if it's a good paint product, the structure is still 40-plus years old as it exists today. So you're really just putting a coating on it and prolonging the, moving that down the road a little bit when you have a structural issue at that lift station. So by doing this, by looking at it and redesigning it, we got it up to today's standards from the Kentucky Division of Water standpoint. We also upgraded the electrical systems to include the generators. It's based on discussions with the operator and based on discussions with the system board over there and what they actually needed as far as the functionality of the system. And we also looked at it from a maintenance and operations standpoint. The original designs didn't include rail systems for the pumps to slide into the structures on, which made it very problematic. The operators were actually carrying around a A-frame tripod, so to speak, to each lift station, and they'd put it on there, and they had a kind of a system that they had devised, improvised winch to pull these pumps out of the bottom of a 20-foot deep structure. It was a very unsafe environment, and we just felt like they needed to have a rail system in there to make that operation much smoother, keep everything operating for them.
The
That
other
pretty well
thing I
covers
want to update y'all on is that there was actually drawdown on the federal monies for valves, and the valves were the wrong valves. So they've got to go in and basically we've got these valves. Now, we may be able to work with somebody else if they need these valves, but I guess they were gas valves.
I have not concluded that yet. That was
Okay.
based on our discussions with the operator. He felt that some of the ball valves were gas valves. We did have some information on some check valves. The check valves, they could operate in this system. However, they're not desirable from an operation standpoint. All the parts are internal, so if you do have an issue, you don't have a way to manually operate the check valve from the outside of the valve itself, which makes it very problematic. You have to shut the whole system down and do any maintenance on the valve. So our recommendation would be to use a different valve. Obviously, it's up to the district and
Sure.
the board to decide that.
I just want to bring that to y'all's attention. That's why if you're thinking, you're seeing this cost difference, because I know when I first saw it, of course, understanding what y'all were going to do, it was anticipated. But this project will literally fix what's needed in Aurora in District 1.
It takes care of the collection system problem, getting all the waters to the treatment plant. Doesn't address the treatment plant
Right.
inefficiencies right now, but it does address the collection system pumping issues.
Is there, are we on the line for this amount, or is Sanitation District 1 on the?
If you remember I forget which year it was, but the district had voted, they increased the state parks agreement, and that increase is what was to pay back the loan, the original loan.
So
And that
that's
was on
going to
the-
pay back this loan?
Yeah, whatever that increase was is to pay back this loan.
Okay, and so there is a business plan. You all are satisfied with the business plan in place to service that amount?
I haven't seen the plan, but it's my understanding, yeah, I think there is a plan in place, and that would be worked out between the sanitation district and the fiscal court. Yes, sir.
Those plans, such plans have existed in the past.
Yeah.
And in the sanitation district too, and before the majority of us got here, and there's been no payment whatsoever.
Mhm.
So I would certainly like to see, I mean, I agree with what the judge said, we don't need to Band-Aid it, we need to fix it. But there needs to be a business plan so that, and just say, instead of saying, I mean, I'd like to see the business plan and see if those numbers will pay that back.
Mhm.
This is a separate entity from this body here, and I don't mind loaning and working with them and so forth. I want them to thrive too,
Mhm.
because when they go well, we go well. But I'd certainly like to see the business plan to make sure that it's sufficient to pay back this amount, or at least make an effort to.
Which district are you talking about?
This, the one we're talking about right now, both of them really, but this one that we're speaking of right now,
I mean, I've seen the original business plan for District 2. District 1,
well, that's what we're talking about now. That's what I was talking about. I would like to see them both, but in particular, we're talking about sanitation District 1 and this proposal and bid opening and so forth, and I just haven't seen the business plan that allows that return of this investment to the county, to the taxpayers. So I'm talking about sanitation District 1 business plan.
Understand?
I don't know if there is a business plan for District 1.
Well, to say I mean, you all have a plan as far as.
We have a plan, but it's not compared to District 2.
That's correct, yeah, and.
Oh, I'm
what
talking
speaking
about
to-
the numbers for the return on the investment. We are loaning these entities the money, and obviously, I would hope we're not going to, or I'm certainly not going to, loan them the money if there's no plan to pay those monies back. And
Well, the plan, if you look back when the court originally did this, the plan was that increase with the state park, because their revenue.
yeah,
There was
I
there was
understand that.
grant dollars, and then there was a loan, and the increase at the state park was going to cover the service in the loan. Is that, I guess,
All
I
that's
guess the
got to be
question
in
is,
writing
that
though
still
somewhere.
I mean,
viable?
yeah, because with DRA, those funds are still there.
Right.
We're drawing down those
Right,
funds. I mean,
that's not significant to do that, but certainly I think it would be wise to visit that and see if, you know, I've heard the same thing too, but I haven't seen it on paper.
you haven't seen what,
I haven't seen that the state park increase in fees are going to pay for this. Somebody surely put a pencil to it.
there's actually an agreement. There was an agreement done
Right.
back then.
Right. Then, so that with this amount, we can feel comfortable on recouping our monies with that. I just, you know, nobody has seen the business plan. Certainly, you got to have a business plan.
If you remember, in early 2016, when the bids came to us, the only issue then was that there was only one bidder.
Mhm.
And then we had, they rebid, and then we had 3 bids. The business plan wasn't discussed then. The way it was set up then, I think it was 2011 when they started this,
Mhm,
was that the
2011,
increase with the
2012,
state park and that increase with the DRA funds and then the loan that the fiscal court would take out, that was the plan.
Right, and that's what concerns me. There was no plan for the other $245,000.
Well, that's the problem, is that the project, the scope of the project, that's why I had him explain it to you, was putting a Band-Aid on the
Right,
project.
I understand that too.
The payback is just going to take longer for that district to pay it back.
But I did,
But that, I mean, if
But
you're
it'll
talking
be
about a
covered.
plan, that
It'll
was a
be covered.
plan.
I mean, the
Yeah.
district won't be out anything other than the funds coming in from the park, which is gonna continue as long as that loan
But
is.
what are
Right.
those funds? Are those
Active.
funds sufficient to pay this amount back is my question.
What do you mean sufficient?
Just what I said, are the funds sufficient to reasonably be able to pay these monies back to us that we're on the dotted line for?
That's all they've got, Rick. I mean, I don't know, that's all they've got. That district has
But
got.
what are those figures? Does anybody know what those
Yeah,
figures are?
there's a contract. The contract, I think we presented that back, we discussed that back. Can you pull that up? It's been discussed in court. It's been agreed upon. I mean, that's what I'm trying to say. If you're comparing that business plan to F&H's business plan in
Oh, no,
District
no,
2,
no, no.
it's totally night and
Oh,
day.
I understand that. I understand that, and I'm off. I agree 100%. It needs to be fixed right instead of Band-Aiding, because, you're gonna be Band-Aiding again, putting a new Band-Aid on until you use the whole box up. But, like I say, I just want to make sure that I just never have seen the fact that will that amount pay back service this loan?
That's the amount
And-
that they have to pay on the loan.
That they what?
That's the amount that they have.
That they paid, okay.
That's
That
all
they're
that's all
paying-
they
that-
have.
That they're paying right now. They're paying that amount, okay. Can I get a copy of that?
Yeah. Yeah. The district, if you go and look at that district, the customer base and the revenue, they don't have the funds. I mean, this is it. This is the only thing that they could negotiate. The ERA funds that came in to help was $300,000.
Right. And this body, before we got here, had pledged $245,000, something like that. I can't remember the exact figure. On top of that, Delta Regional, $300,000. But when we started looking, to date, all those $300,000 funds, those funds hadn't been expended, and we had no preparation, or this body had no preparation, the powers that be had no preparation to pay it back or a business plan. Just want to make sure we're not going to get in one of those kind of deals again. I understand that money will fix anything, but my question is, will that fee right there service this debt? If you would go to a bank and borrow money, they're going to ask the same questions. How are you going to pay us back? And this is taxpayers' money separate from an individual. This is a totally separate entity, and I'm asking those same questions. Will that service this debt, or will we be just spinning our wheels and never get those monies back?
We can take a look at the details as far as the agreement. But at this point, the district, the project that's in place, it's closing up the project. DRA, those funds, it's been clear from Delta Regional Authority, if this county does not get any skin in the game on this project, they're going to pull those funds. And then the district's even going to be in worse shape. At the end of the day, the position that we're in, guess who it's going to fall back on? Guess who it has fallen back on? The county. I understand you want to talk about a business plan. We've got a project that has been on the books since, I believe, 2011, 2012. This is the last project that we need to get completed. That district has got challenges. We all know this.
I agree.
The revenue stream that they've got, that's all they've got. And if it means we have to go into an agreement with the district that the county helps fund, and then over the period of however length of time, that amount of revenue that they make pays it back, that may be the course that we take.
That's fine. I think that needs to be in place, though. There needs to be a payback in place. I mean, So if you're going to a bank to borrow money, they would do the same thing. We're responsible for
I think
those
it is in
tax
place.
dollars.
Something we've got to do.
Yeah, no, it's gotta, I mean, they gotta be fixed.
Of course, we'd love to be reimbursed.
The goal is to get reimbursed, it's just the
I mean,
time.
it should, that doesn't, that's my understanding anyway, from this document. That doesn't limit how long the park pays this amount. That just limits that amount can't change for 5 years.
That's right.
The district, if they need to, or that can be renegotiated then
That's
after the
right.
5-year period.
5 year started, Bob?
It would have started, I don't know, man, it started 2 years ago. I don't know exactly
don't-
when the first payment was made.
I don't know, and,
It's been in place since I've been here, so it's been over 2 years.
well, the agreement was changed.
Yeah.
The agreement was modified. The other thing is that that's the largest customer, and there's no meter. We've actually even discussed metering, so that we can get a true value of what's coming in. So there's options on the table for the district as far as a revenue source. But what was in place back then, this is it. This was the decision to increase that contract with the DRA funds and the court helping financially. The only thing that's changed is our 275 is increased to
Right.
cover the project. But the actual agreement, how it was set up, has been consistent. We can show those numbers. We can show you what that number breaks down to, but there's nobody else that's in line to pay it. I mean, we're it. But we can do that. Is there any other questions on that, on the District 1 project? And we can get that for you. We can show you what the numbers are. We can break that down and put the pen to the paper. But as far as, I just want to make sure I'm clear, as far as a business plan, that's it. That was what was put in place. As far as Rivercrest, they held the bids. They selected Youngblood. Do we need to, we've already got them moving forward on it. Do we need to take action on actually
Accepting the bid.
accepting the bids?
Has the board acted?
The board voted for Rivercrest to manage it. They did the bids.
Yeah.
And then they selected, Rivercrest selected Youngblood.
Okay.
I mean, is there any action that we need to accept the bid since they,
Well, I mean, is your name going to be on the,
I guess it would be
On the
safe to
loan?
go ahead and do it.
I'd safe thing
Yeah.
would be to vote.
Okay. Be the safe thing to do.
We have given them the authority anyway, but
Correct.
we need to vote.
I'd move that we accept the bid of Youngblood to move forward with the Aurora Lift Station project.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries, and we'll get that information to the court that Rick was
And
talking
the
about.
only confusion is that you've got two legal entities that are involved, and, you know, I mean, the plain and simple of it is that the county's going to be ultimately responsible regardless, so,
That's my point exactly.
Yep.
yeah.
As always.
I mean, at this point, you vote on it just to make sure you clarify the record, but it really doesn't make a lot of difference.
Sure. Well, I mean, and they voted, the district and the court voted back in.
Yeah. Well, it shows
2011 or something.
consistency, and,
Yes.
I mean, I assume that they advertised, you helped handle the bid, they advertised and didn't jump through all the hoops?
Yes.
Okay. That would be the only concern because I haven't seen any of that.
Yeah.
I don't know if Chad is involved in it.
We're gonna jump down to new business on, if you don't mind sticking around. Sanitation District's accounts receivable. we'll go ahead, since you're here, Chad, and I see the chairman of District Two's here. We're going to go ahead and update the court on both District One and District Two's accounts receivable.
I used to do payroll reimbursement and accounts receivable monthly when the sheriff was fee pooling to disclose how much he owed us at that point. Given the situation with the sanitation districts, I wanted to inform the court that sanitation district number 1 is, they only owe $32.93.30. That's one payroll is what they owe. Sanitation
Say that again.
Sanitation District Number 1 owes the general fund $32.93.30 for payroll. Sanitation District Number 2 owes the general fund $21,868.03. Then, with the new employee for Sanitation District Number 2 that is currently county paid, that amount is $2368.18.
In addition,
Yes.
23 what?
$2368.18. It was my understanding that the court was paying for that employee at this time, and it may or may not be included in the repayment plan or not. I'm not.
We wanted to update the court, and I got the individuals here. If there's any questions on this, Emily put the numbers in place so that you can see it as far as where we are currently. Y'all have any questions?
I guess Emily brought one up there, the employees, we are there, I know they're county employees now, but that's not in any rebate, any payback plan?
When you all approved to shift that employee over there, I believe I asked if that was a fiscal court paid position, and I thought everybody understood that it was at that time.
Right,
So-
I just thought they're just like many of our other positions in Jeff's office and other offices, we are reimbursed for that employee. I'd assume that's what it was. That's not the case. I'm just asking.
No, that's the case. These are the numbers.
Okay, those are the numbers that are proposed to be reimbursed.
So do I need to start billing
So that, okay.
sanitation too for Jonathan's
No,
salary
not
and
Jonathan.
fringe? Okay, I think that's
Jonathan's
what,
totally different. These numbers should be for Lindell and,
yes.
Okay, and why would Jonathan not fall in that category?
we're keeping Jonathan in a contingency amount. We're keeping his as far as the totals to the district. But the districts they don't have the money. And they've got, especially District 2, we've already discussed Department of Water and the issues that they're in. So Jonathan was to be brought in to help the district get in compliance. He was already a county employee. So unlike Lindell and Lindsay, they weren't county employees.
Those funds can also, certainly we're gonna have a record of those, and that can actually be used to mitigate if the state wants to come back with any fines or any way that we can actually use those funds to mitigate those fines.
Do y'all have any questions while the chairman or the engineers are here? The thing to understand is we know the issues that the district has in place. When we took this over, they were in the red. There was arrears. The revenue that the district has coming in, they were paying off the arrears. They're aware, especially District 2, they're aware of the payments. And with their revenue coming in, they can put towards those payments about $1,000. But their goal was to pay off the arrears that were already put on the district. I wish I could tell you it's easy, but this is a complex situation to get this district in compliance. I can tell you that over the past year and a half, where they're at today is huge strides, and I applaud the engineers and the board members and Lindell for the work that they've done, but they couldn't have done it without the county stepping in and helping. But we felt it was our responsibility to update you on the numbers so that you can see it. They're aware of it, but the biggest thing was their arrears. They felt they needed to be paid first. Y'all have any questions on that? Okay. We'll move on with correspondence. Thank you, Chad.
Thank you.
Under correspondence, notice of proposal to construct wireless communications facility. I'll just read this. This is Pike Legal, notice of proposal to construct wireless communications facility, Kentucky Public Service Commission. Site name, Calvert City. Dear Judge Neal, Skyway Towers LLC and Kentucky RSA #1 partnership. Verizon Wireless filed an application for the Kentucky Public Service Commission to construct a new wireless communications facility on site located at Gilbertsville Highway, Kentucky Highway 282, Calvert City, Kentucky. The proposed facility will include a 255-foot tall antenna tower plus a 10-foot lightning arrestor and related ground facilities. This facility is needed to provide improved coverage for wireless communication in the area. You have a right to submit comments to the PSC or request intervention in the PSC's proceedings on the application. This was just to notify us that they're putting that tower in place, and it's more of a legal requirement to notify us, but I just wanted to read that to the court so that they know that that's taking place in
Where on
Calvert.
282 is that, you know?
It's right before the Eagles.
Right before the Eagles on the Calvert City side?
I think it's Skyline Drive. If you look at the map, it shows you right there where it's
Okay.
going.
Do you have a contact information for them?
I can give you a copy of this.
Please do, because we're looking at infrastructure for our.
Adding something to
She
it?
said draft.
Yeah. Yeah, I'll have Des forward that to you. Y'all looking to put something on the pole? Under correspondence, public notice, this is for ISP Chemicals tentative decision to renew a variance for waste designation. Again, this is just a public notice. Dear mailing recipient, this is from the Energy and Environment Cabinet. Enclosed with this letter is a notification of intent of the Kentucky Division of Waste Management to approve a proposed activity. The proposed activity applies to an entity regulated by state and federal environmental regulations and/or statutes. You're being notified of the proposed activity due to public notice requirements within Kentucky administrative regulations. Per these regulations, the following entities are required to be notified of the proposed activity. Any agency which is issued or is required to issue an environmental permit for the reference facility, federal and state agencies with jurisdictions over fish, shellfish, and wildlife resources, and agencies governing historic preservation, persons requesting to be placed on the mailing list, any unit of local government having jurisdiction over the area where the facility is located or proposed to be located, persons potentially affected by the proposed action such as local residents. You have received the enclosed information due to meeting one or more of the above criteria. If you have any questions or wish to comment on the proposed activity, please contact the individuals referenced in the notification. Any action taken on your part is strictly voluntary, as no action is required. And that's from April Webb, Manager, Hazardous Waste Branch. Again, these are just notices that we're reading. We'll upload these on the county webpage so that if the citizens want to go to that webpage and get a copy of it, they can. Under correspondence, this is from the Marshall County Wheelchair Ramp Ministry. Dear Sirs, To Judge Executive Kevin Neal and County Commissioners Bob Goad, Johnny Bolin, and Dr. Rick Cock, thank you for the recent donation of $3,000 to the Marshall County Wheelchair Ramp Ministry. For several years, volunteers have worked to build wheelchair ramps for individuals in need, not only in Marshall County, but in various locations throughout the region. Many families and individuals are able to reimburse the ministry for the cost of materials to build the ramps, but we build the ramps and remove them when they are no longer needed without requiring payment. Your donation helps sustain this service, and it is greatly appreciated. And that's from David Burnt and the rest of the members of the ramp ministry. And that's in response to the grant application that they had filed and the court had approved. So this is under correspondence. This is from the Office of State Budget Director. We received this September 7th. It's to all Sears employees. Attention Chief Executive Officer. It's from John Sheldon, State Budget Director. I'm writing to provide an update on the status of pension reform as it relates to the county employees' retirement systems, CERS, of which your organization is a participant. The current situation required pension contributions will continue as a percent of your organization's actual payroll, assuming no legislative changes occur. The rates that will apply for FY 2018-2019 are substantially higher than the previous years. The increase arises primarily from revised actual assumptions that the KRS Board believes are realistic and which will result in immediate decreases in the unfunded liability. The most significant revised assumptions include the long-term average investment rate of return, 6.25%, previously 7.5%, and the payroll growth at 2%, previously 4%. The preliminary rates for FY 18-19 are shown below. For reference, I have included rates that apply to KERS and state police plans. If you look at the box there, it's got the Sears plan, percent of payroll, the Sears non-hazard, owed assumptions 19.18%. The revised assumptions 28.86%, for an FY 19 increase of 50.47%. If you look at the hazardous under Sears, the old assumption is 31.55%, revised assumptions 50.67%, with the FY 19 increase at 60.62%. And then out beside it, it's got the other KRS plans, the KERS, non-hazard and hazard, and then the state police retirement plan. It's got their percentages. Reading further, you can determine the projected increase and the impact on your budget by referring to the schedule that accompanies the memorandum. Note that non-hazardous and hazardous amounts are on separate lines. Reform efforts, as you know, discussions about changes to the pension system have become more intense since PFM Group Consulting LCC presented their report number 3, recommended opinions. That report presented options that Governor Bevin and legislative leadership are evaluating and considering. The recommendations provide a framework for the legislation to be proposed in an upcoming special session of the General Assembly. This will be available. We're going to upload this to our webpage. I've had several employees contact me as far as the pension issues. I'm sure that the leaders within the departments have been dealing with the same questions. So we wanted to update this just to keep everybody informed what the information that we're getting from the state cabinet as far as what can be proposed.
Well, that being said, nobody needs to panic at this point.
Sure.
Nothing's been done.
Correct. And that's a good point because I know people call, they've got concerns, rightfully so, all of us do, but the biggest thing is to get educated on what's going on and definitely be prepared whenever the session comes in and what the bill is. I know there's some links out there that may be something too that we upload to the webpage so that they can go on, they can do a bill watch and actually watch the bill as it is presented. And the employees can stay in touch with that. I know there was a meeting down in Paducah that several of the county employees attended regarding the retirement system, so, but we just wanted to update that and we'll put that on the webpage.
I also want to add this, keep the pressure on our legislators, keep calling,
Yep.
don't quit calling, call them every week.
Judge, before we move on, are we through with correspondence?
Yes.
I think maybe, did you not receive a letter from the city of Calvert City on the wellhead protection?
I did.
Okay. Can we, I promised the people in my district in that wellhead protection area, and as well as Mayor Jones and the city attorney promised them to keep educating and updating them, and I think Bob got one. John, did you get one too? Can we put that on our website, so in case those 56 residents that were here to educate them, this is a second round of information that Calvert City sent out on their behalf so that to calm their fears, and if we could put that on our website, I think that would, all those people got this letter, 56, but in case something went wrong with the Pony Express Postal Service, then maybe they can get an opportunity to view that again, but they continue to upgrade it or update and educate those people, so as they promised, and I promised, like to read that into the record.
We can put that on the webpage,
Okay.
and they are sending those to those county residents? Okay.
This is the second mailing that they've done since they were here and asked and were granted wellhead protection authority, and they will continue to do that. There's a plan already for another one to go out to address their concerns.
Okay. Under old business, approve the minutes for September 5th.
To approve the minutes, Judge.
Second.
Is there a second? I didn't hear.
Yes, second?
All those in favor say aye.
Aye.
Any opposed? Motion carries. Under new business, agreement and resolution, Kentucky Transportation Cabinet, it's Green Acres Lane. Wendy, do you want to give us an update on that?
Removing the tank car that's in there and replacing it with aluminum box culvert, kind of like what we done on New Harmony. We got 80/20 funding that this agreement is for that.
You know yet how you're gonna bypass it while you're working, or?
Well, we've got permission from the landowner on the right side of the road going in to, we'll probably pull the tank car upstream and build the road around it, so we can build it in the hole.
That'd be good.
When are you going to start that?
Well, as soon as we can get it all ordered, and I ordered it this morning, so it'll take probably about 4 or 5 weeks to get the material in. Hopefully weather will hold out so we can get it done.
Before this year?
Yeah.
Okay.
Just need a motion to enter into the agreement with the
Yep.
state. Motion to enter into the agreement for the 80/20 match.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries.
Does that eat all our 80/20 money up, Wendy?
No,
Is that it?
no, we still have some.
How much is some? Ballpark?
Yeah,
I'll ask you
I
later.
can't remember. I've got it on my desk.
I'll get it later.
And then let you know.
And I know you know this, but I just want to make sure, that until this resolution is signed, we can't do any work, so it's. Final county appropriations for the PVA FY 17-18. You should have that in your packet. Is Tony coming down? I think he's going to be here if y'all have any questions. But he put a very detailed packet together.
Basically, due to our assessments coming up and the way the state looks at those, it threw us into a higher bracket.
Which is a good thing.
The $25,000
But
is
it
not good,
costs-
but the increase is
Gonna
Right.
definitely a good
Right,
thing.
so it throws us up into a $100,000 range instead of the
Right.
$75,700 range, which was our statutory contribution. Since we went over, I believe it was 5.5 million, or, no, it was 550 million, then we get taken up into that next bracket. So, we just wanted to let you know, I have funded that increase in the budget amendment. But we wanted to let you know that there will be another $25,000 that we will need to pay to the PVA office.
Yeah, I mean, it shows growth, and the good thing is the 500, the next bracket to go into, we don't project going into that anytime soon, so. But, do y'all have any questions on that?
Good timing, Tony.
Yeah. The court just needs to make a motion to approve this.
Move, pay the bills.
Second, all those in favor say aye. Any opposed? Motion carries. Appreciate it, Tony. The Veterans Band Fund, we closed that out. There was some interest earned, $4.69. We're basically just looking to move that out of there to the Veteran Support Group so that Emily can clean that bank account up.
Make that motion, Judge, move those funds.
Second.
Those in favor say aye.
Aye.
Any opposed? Motion carries. Bid advertisement for surplus sale. Wendy, you want to update us on that?
Yeah, we have a dozer, skid steer, and roller, and then, 3 pickup trucks that we're needing for the surplus sale. And then there's just some miscellaneous items too, so I'd like permission to advertise for that.
Advertise for bids on the surplus sale.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. The next is the bid advertisement for the budgeted skid steer.
Yeah, we're wanting to, of course, surplus our other skid steer, it's too small. We're working towards getting a stump grinder for a larger skid steer so we can grind all the stumps where we're cutting all the trees back in the fall on all the roads, so we won't be leaving the stumps there to hit with the mower the next year, so.
Motion to approve that bid advertisement.
Second.
All those in favor say aye. Any opposed? Motion carries. The 2017 tax rates.
Marshall County Fiscal Court Order 2017 tax rates, an order relating to the adoption of the 2017 Marshall County tax rates. Whereas the Kentucky State Revenue Cabinet has certified the Marshall County property assessments as real estate, $1,879,196,789. Tangible personal property, $229,987,543. Public service companies, $108,862,132. Motor vehicles, $261,870,633. Watercraft, $24,944,506. Aircraft, $60,000. Watercraft non-commercial, $74,423,381. Inventory in transit, $125,296,397. Now therefore, it is ordained by the Fiscal Court of Marshall County, Section 1, in accordance with KRS 68.245 through 68.249, there's a levy for year 2017, that general ad valorem tax for $100 assessed valuation on all taxable property within a jurisdiction for the general fund and such additional tax rates for each special district or other fund as indicated. General fund, real property, 9.6, tangible, 9.6. Health department, health district, 7.25, tangible 7.25. Hospital, real, 3.8, tangible 4.3. Library, real, 9.4, tangible 9.65. Refuse, 9.1, real, 9.0, tangible. Extension district, 1.8, real, 1.85, tangible. Soil conservation, 0.5, real. Gilbertsville Fire District, 7.5 real, 7.5 tangible. East Marshall Fire, 9.4 real, 9.4 tangible. Possum Trot Sharp Fire District, 6.8 real, 6.8 tangible. Bryansburg, Palma Fire District, 10.0 real, 10.0 tangible. West Marshall, 7.5 real, 7.5 tangible. Verdine and Olive, 10 real, 10 tangible. Section 2, in accordance with KRS 132.487, there is levied for tax year 2018 tax rates of 11.2 cents per $100 of the taxable value of motor vehicles and watercrafts registered in Marshall County. Section 3, in accordance with KRS 136.575, there is levied for the year 2017 the tax rate of 25 thousandths of 1 cent on bank deposits held by all financial institutions within the County of Marshall. Section 4, this order shall be published within the Tribune Courier newspaper by title and summary within 30 days following adoption. Section 5, this order becomes effective upon passage and publication.
Thank you, Ms. South Marshall's tax rate.
South Marshall's 9.5 and 9.5.
Okay.
Oh, yes, it's at the top of my same page.
Emily, were any of those increases over last year?
Let me pull that out. I knew you were going to ask me that.
Did they remain the same?
Everything remained the same with the slight fluctuation of the calculation that you have to use due to your
Right.
certifications. The differences were the general fund, in 2016, we were 9.7 and 9.8. This year, we're 9.6 for both.
So that's a decrease, obviously.
Technically, per the rate, however, it generates the same
Right,
revenue.
right.
Library was 9.76 tangible, it's now 9.65. Refuse district was real
Well,
estate.
that's a slight increase. Okay.
Refuse was 9.2 in 2016, so that's a slight decrease. And the extension district was 1.8 real this year, and last year it was 1.769. I think they just rounded that up. And it was 1.85, no, it's 1.85 this year, and it was 1.83. So it's only slight differences.
What about the fire districts?
They're all the same.
They're all, okay.
We just need a motion to accept.
Motion to accept the 2017 tax rates.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Next on their new business, rural water resolution. Brad, you got a copy of that? All right. This is the Marshall County Fiscal Court Resolution Number 2017, resolution of the Fiscal Court of the County of Marshall, Kentucky, authorizing the filing of a petition with the state local debt officer for approval to finance the cost to make extensions, additions, and improvements to the Marshall County Sanitation District 1, the Marshall County Sanitation District 2. Recitals, the Fiscal Court of the County of Marshall, Kentucky has determined that it is in the public interest to make extensions, additions, and improvements to the Marshall County Sanitation District 1, the Marshall County Sanitation District 2, collectively the project. And B, the county desires the Kentucky Rural Water Finance Corporation, the KRWFC, to act as its agency and instrumentally for the purpose of providing monies to the finance to the cost of the said project, has made an application with KRWFC, therefore. And C, it is necessary and appropriate for the fiscal court to authorize the petitioning of the state local debt officer to approve a loan to the county from KRWFC. Now therefore, the fiscal court of the County of Marshall, Kentucky does hereby resolve as follows. The fiscal court of the county does herewith express its intent to obtain a loan from KRWFC in the approximate principal amount of $625,000, the loan to finance the cost of the project, which loan will be secured by a general obligation pledge of the county's tax receipts. That the fiscal court authorizes the county judge executive to execute a petition to the state local debt officer on behalf of the county requesting the state local debt officer approve the loan. This resolution shall take effective from and after its passage and approval. Adopted at duly conveyed regular meeting of the Fiscal Court on the County of Marshall County on September 20th, 2017.
And I'll make the statement that by adopting this attached resolution, the fiscal court will not be obligated to take these funds. It's just another step into the process of the application.
Applying for the funds, we're not obligated at the time, okay?
Motion to approve the resolution, Judge.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Ordinance 2017-11, budget amendment, first reading.
Ordinance 2017-11, an ordinance relating to the annual budget and amendment thereof, whereas the County of Marshall has received additional funds. Now be ordained by the Fiscal Court of Marshall County that Section 1, the annual budget for fiscal year 2017-2018, is amended to increased revenue accounts for U.S. Fish and Wildlife, $4,621. Underwriter safety and claim for our 2017 Durango was $500. Our 2013 Tahoe was $657.86. Our law enforcement program grant is $17,290. That's the body armor grant. AOC is $2088.40. That's for LED lighting outside the judicial building. Port Authority is $802.07. Beginning cash balance, $37,011.26. Truck license distribution, $15,064.30. Driver's license refunds, $57.50. Kentucky Flex funds for 2016, $250,271. County Road Aid fiscal year 17, $151,703. Road signs, $904.55. Underwriters, guardrail repair is $1,685. Miscellaneous revenue from the road fund, $2,095.04. Beginning balance on the road fund, $15,390.75. Inmate housing for other counties, $7,959.20. Delta Regional Authority grant, $49,904.35. Beginning cash balance for 911, $929.81. Veterans van interest earned, $3. Veterans van prior year balance, $1.69. And prior year balance for building inspection, $33,661.50, for a total of $592,601.28. Increased expenditure accounts. Fiscal court legal fees, $5,000. That was, the sexually oriented businesses expenses for that ordinance, Mr.
Bergdahl.
Yeah. Senior citizens health insurance, $8,750. General fund reserves, $3,157.23. PVA increase, $25,000. GIS insurance offset, $500. Sheriff's office insurance offset, $657.86. Sheriff's office deputy expense, $12,290. Sheriff's office court security expense, $2,500. Sheriff's office court security equipment, $1,500. Sheriff's office court security supplies, $1,000. Judicial remodeling projects, $2,615.50. PVA, already said that one, statutory. Road Department advertising, $2,000. Road Department tank cleaning, $3,000. Road Department equipment rental, $10,000. Road Department striping, $20,000. Road Department building repairs and expenses, $160,000. That's to include the repairs from the storm damage. Road sign materials, $5,000. Bridges, $50,000. Snow equipment, $20,000. Reserves, $167,171.14. Jail fund food, $79,59.20. Delta Regional, $49,904.35. 911 reserves, $929.81. Veterans van, $469. And building inspection reserves, $33,661.50. $592,601.28. For 592,601.28. The amounts added to the revenue expenditure accounts in Section 1 are for governmental purposes.
Questions?
Motion to approve the ordinance 2017-11.
All those in favor say aye. Any opposed? Motion carries. Ordinance 2017-12, Industrial Development Authority, first reading. This, I know Josh is here, but Marshall County Fiscal Court Ordinance number 2017-12, an ordinance creating the Marshall County Industrial Development Authority, whereas KRS 154.50 provides that a local government may, by legislative act, create an industrial development authority to help promote and stimulate industry and commerce within its community. Whereas the Marshall County Fiscal Court does wish to take advantage of this statutory authority, now therefore be it ordained by the Fiscal Court of Marshall County as follows. Section 1, there is hereby created and established the Marshall County Industrial Development Authority Board. The board shall be vested with all of the powers and duties as provided by KRS Chapter 154.50 or other applicable state laws. Section 2, the board shall be comprised of 7 members appointed by the judge executive as provided by law. Members shall serve 4-year terms with initial appointments as follows. 2 members shall be appointed for an initial term of 2 years. 2 members shall be appointed for an initial term of 3 years. And 3 members shall be appointed for an initial term of 4 years. Section 3, the board shall meet not less than once every other month, but as often as necessary to carry out the powers and duties of KRS Chapter 154.50. At the board's initial meeting, the board shall designate a regular place and time for when and where meetings shall be held and shall comply with KRS 154.50 through 336 by electing officers as required by that provision. And the board is also empowered to enact bylaws as deemed necessary. The board shall be subject to Kentucky's open meetings and open records laws. First reading of ordinance 2017-12.
Do we not have a similar board already?
Do we not have a what?
Similar board already. This is creating Marshall County Industrial Board. I thought there was already one.
Are you referring to the City County Industrial Board?
Maybe. I don't really know. I guess I am.
I don't know, are you?
I guess I am. I thought there was a Marshall County Industrial Board.
There's not a Marshall County
So,
Industrial.
but there is a City County Industrial Board. Okay, well, what about that when we're going into forming another board, is that one going to become inactive, or what are we?
Well, putting in place an actual county industrial board, the county, if there's any action that's needed at the county level, that's all you have. You got the county involvement. If there's monies to be negotiated, if there's actually any agreements that need to be negotiated, you don't have anybody but the county involved in that. There was, I think 2009 was the last activity on the City County Industrial Board. It wasn't until 2016, till I made my appointments, that there was actually activity, and that was because Stave Mill, Josh had some information that there was a company coming in, and that board worked with Stave Mill and Champion Homes. That was a city-county effort.
So I think, just for clarification, the city-county industrial authority is an interlocal agreement by which the judge appoints 3 members and the mayor of the city appoints 3 members. So this would just be a standalone in case there were to be something outside of those.
I know how that works.
city limits. Okay.
I was here last month at that meeting myself when officers were elected and so forth, and there's monies in that pot.
Correct.
I don't see any issues really with the smaller cities that we have, of course, being actually a rural county. I don't think everybody realizes that, we got a Murray or even a Mayfield, of those size cities. There are grants, there are dollars out there that they can get, that our cities cannot because of their size. And really, the economic development kind of falls on the county.
Right.
More so in our situation than in a lot of others.
Yeah, and if you go back and you look at the history of the City-County Industrial Board, how it was developed for a specific project.
That's correct. So yeah, this is really, and I'm glad that the judge has taken on this initiative. It's basically just an avenue for the county, the fiscal court to have their own industrial development authority in the event that
Right.
it's needed.
Yeah, there's nothing that says that this board can't work with the City and County Industrial Board.
Correct.
Those channels are always open.
Make a motion, we approve this ordinance.
No, I think I'm sorry, Bob. I think it's first reading.
First reading,
Yes,
okay,
sir.
we don't do that.
Yep.
Well, you can put a C up there at the
Yeah.
top instead of an N.
Yeah, you catch that too. Any other questions? I know you're sticking around.
Yes, sir.
Okay. We already did sanitation districts accountable receivable. We'll move to K on the agenda, appropriations transfer.
I'm asking your permission to move $1,100 from workers' comp insurance to the county insurance to cover our drone policy.
Motion to approve the appropriation transfers.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Treasurer's report.
As of August 31st, 2017, the general fund had a book balance of $333,714.27. Road fund, $1,838,692.54. Jail fund, $317,947.74. The grant fund, $27,140.31. 911 fund, $109,919.67. Occupational tax administrator, $5,188,805.52. Veterans van fund, $4.69. ABC fund, $146,502.63. Building inspection fund, $45,989.28 for total reporting funds of $8,008,716.65.
Motion to approve treasurer's report.
Subject to audit. Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Approve payment of the bills.
Motion to pay the bills, Judge.
Second.
All those in favor say aye. Any opposed? Motion carries. Let's see, I've got here as an announcement, the second reading of ordinance 2017-11 and 2017-12 will be October 3rd. That'll be our next scheduled court meeting. We've got several things that need to be discussed in executive session, both real estate and personnel.
And litigation.
And litigation.
Judge, may I?
Yeah.
I'm sorry to interrupt. I should have said something while I was up here.
Yeah.
Independent Stave Company will be having a job fair on September 27th at their location off of Mayfield Highway. That exact address is 4377 Mayfield Highway. For those that might be watching, you can also go to independentstavecompany.com/careers, and the jobs that they're hiring for are on that website.
Okay.
But September 27th, they'll be having a job fair at their location.
Okay, and we're gonna, that email, I think you were involved in CC'd on that, but we were gonna post that on the webpage too, so if there's anybody that's watching, they can go to the webpage and get that information as well. Appreciate it, Josh. We need a motion to go in executive session.
Motion to go into executive session on real estate, personnel, and litigation.
Second.
All those in favor say aye. Any opposed? Motion carries. We had several things that we had discussed in executive session. Correct me if I'm wrong, we only have one item that requires.
Bob's not here.
We'll wait for him to get here. But we had several things that we had discussed in executive session. Did we need to take action on the land, the one that you brought up?
Well, yeah, I mean, that would have to be
Or is that something
to
that
accept the
we'll present next?
property and to take that The other one is that road, section of road would be taken into the, based on the petition that you've already reviewed and had a public hearing over.
Okay, so we're prepared to take
You
action.
can do
on it.
that.
Okay. Way Avenue, or is it Way Lane?
Way Lane.
Way Lane. There was a petition that was filed with the Fiscal Court, I think it was last year. And in that petition, the court had dismissed it. Since then.
No, you did not dismiss it.
Or we didn't
You tabled
dismiss it. We didn't
You
take any action.
You didn't vote on it.
Since then, there has been some land that is going to be donated to the Fiscal Court for District 2 with their affluent. Basically, the district wants to extend an olive branch to the Chestnut Creek residents that have been affected by the discharge by putting in a filtration process to be just another level of filtration in case if the district were to discharge in the creek again. In that transfer of land, I think it's 400 feet of Way Avenue would be taken into the county road system.
There's been approximately $30,000 spent so far on the base, and we lack the blacktop, correct?
Yeah, I haven't looked at it recently.
Yeah, because we reviewed all that back when, but
I know that it didn't have any culverts under the driveway.
I think that I know there's been about $10,000 spent each year to keep that building and that up, so we can check that for sure, but that is the status. And that would be a vote to do that and to accept the deed for that property.
Yep, and Nita's going to prepare that. So we would just need a motion.
I'll make that motion that we fix Way Lane in,
As part of that whole transaction?
yes.
Okay.
Second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. The other item on the executive session was personnel, the dismissal of the 911 director with the information that was discussed. The director, Misty Drew, did appeal, and you heard the appeal information this morning. But moving forward, I'll make a motion well, I tell you what, since I'm the one that filed the dismissal, is there a motion to proceed with the dismissal? Confirm the dismissal.
I'll make that motion to confirm the dismissal.
I'll second. We're going to take a vote. We'll start with Bob. Johnny. Rick.
As we talked about in executive session, I recuse myself following the recommendation of the county attorney.
What was that recommendation?
That I recuse myself.
But I think that in a discussion with my assistants and that issue came up, I brought it to Dr. Cox's attention that that was an issue that could possibly arise. I think he even researched it further and determined that he would recuse.
Right. That was a recommendation I got when you called me last Thursday, and I met you at your county attorney's office, and I also talked to Jason, I talked to Dennis Faust. As I told you and everybody in executive session, I also met with 2 other attorneys and told them of that recommendation, and they agreed that that was good advice, that I recuse myself because the employee was my opponent in the general election, and it was best maybe perceived as a conflict of interest if it went farther. And I took that advice, didn't think 5 attorneys could be wrong.
With the votes casted, I also too vote A All those in favor? Any opposed? Motion carries.
Motion to adjourn.
I have one
Second.
other litigation issue, but it'll have to wait.
There's a second. All those in favor say aye. Any opposed? Motion carries.